sections right next door to those sections speak to the ramifications of maintaining action in the Commonwealth if you don't have the authority to transact business. And interestingly, the wording is a little different. The statutes are not the same. Now here, the holder of the mortgage is an LLC. But I would first look at the corporation statute, which says in 156D, section 15.02, that a court may stay a proceeding commenced by a foreign corporation until it determines whether the corporation is registered to transact business in the Commonwealth. So the remedy is not to dismiss the action with or without prejudice. The most that the court can do is have the discretion to stay it until the plaintiff gets registered.
Is the anson registered or not?
To my knowledge, as of today, they are not. We are working with their in-house lawyers to have that happen as well, but I have not updated the last week. Mr. Blunt probably has.
Ron?
Yes.
What's absent from the paper is this proceeding went before Judge Long on precisely the same issue.
I've talked to Judge Long. That's a moot issue. He says that a similar case came before him. The parties filed an agreement for judgment. He never ruled on the case, and so he said that whatever happened in that case is still irrelevant to this case.
Fair enough. The reason I raised the issue as to its relevance is that Anson Street was aware of this back then. It has continued to proceed without filing, with knowledge that it didn't file. I don't know how many other Massachusetts foreclosures it's been doing in this way, with other lawyers not catching this problem, but you have a willful choice not to register. That's slightly different than, oops, I didn't register, and then asking this court to give them a stay to go forward and register. I checked with the Attorney General's office today. This matter has been pending for a while, and it was pending prior action. They still have not gotten registered, despite knowledge of it, and to reward them with just giving them a stay when they filed this in an incorrect manner to begin with, knowing so, is certainly way of rewarding that behavior. The other thing is, and I'll get to it when Your Honor gives me a moment, I do not agree that the assignment that you have before you is correct. I have other assignments that came after that assignment that exists.
Well, if it came after that assignment, then the person in time is the one that controls.
There are other assignments to other entities. It's AmeriQuest giving the same mortgage they're claiming to have power over to AmeriQuest REO Funding LLC 2.
Yeah, but the question is, did that happen before or after the assignment?
It happened after.
Well, if it happened, it's irrelevant if it happened after.
But
if they had assigned it earlier, they had no authority to assign to this plaintiff. If they had assigned to this plaintiff and then tried to assign to somebody else, it was too late.
they recorded the later ones.
All right, well, I have
that for you today.
Okay.
The documents. And I'm more than happy to present them.
Okay.
I don't have those. But I will say, as to the registering to transact business, the statute is clear that the failure to do so does not affect the contract in the Commonwealth. So the mortgage is absolutely clear. The only question is, for purposes of a service member's action in land court, is that a proceeding whereby a company is availing itself of the court of time? It's been undecided. The Superior Court, there's no question, you can't get a judgment without doing it. Now, cases in other states, like the Mass statute, have said, I'm familiar with Rhode Island because I also practice there, you can file your action when you're not registered to transact business. You can get all the way up to the court brings the gavel down on a judgment, but you can't get a judgment without being recorded to transact, without being registered to transact business. So, again, Your Honor, drawing your attention to the two statutes, they do say that if the court is unsure whether the plaintiff is a foreign LLC or a foreign corporation is not registered to transact business, then the most it really can do is have the discretion to stay the matter until the company does so.
Okay. All right, listen, there are a number of issues here. I'm going to give the parties 2 weeks to file memorandum with the court on 2 issues. One is on the assignment issue. Mr. Bond, did you have evidence that the original mortgagee assigned this particular mortgage to someone else and it was actually recorded? Give me that information. That may be relevant. Mr. Sousa, you can respond to that. The second issue is the issue of whether the anson is qualified to do business in the state and what the repercussions are. I guess he's admitted, Mr. Sousa admitted that as of today they aren't. They're trying to get it. What the ramifications are if they're not qualified to do business here. So I'm going to give you both 2 weeks to brief both of those issues. And then once I get your briefs on that, then I'll make a ruling on this.
Your Honor?
Yes.
May I have a minute?
Yes.
One, I want to correct something. In Harrington versus Cambisi Law Office, 508 F subsecond 128, page 139, a collection suit was filed by the law office, and they were filed on behalf of a foreign corporation.
All right, well, wait a minute. I'm going to give you a chance to brief this. I'm not going to rule today.
I understand that, Your Honor. Fair enough. And the only other issue that I want to deal with is, and I think it's a matter of jurisdiction, is the mortgage they are suing under was terminated and superseded by a modification which was signed by their clients by their own counsel's admission. It's not the mortgage. The mortgage they're suing under, this $211,800 and some odd dollar mortgage, is not the mortgage anymore. It was superseded by the modification that was done to get the dismissal in Judge Long's case. I have the emails from Mr. Mulvey, who currently...
Okay, wait a minute.
Shut up and listen.
The court only goes on the basis of what is of record. If there was a mortgage given from the original mortgagor to X Bank, and then X Bank assigned to Y Bank,
Okay.
that's all the court is going to look at. It's not going to go, I mean, we are just repeated with cases brought by mortgagees who can't pay, and we try to come up with every excuse possible as we try to overturn the mortgage. And there may be some very legitimate reasons, but we don't go into all of these underlying issues, particularly for purposes of a service member's case. The only thing we look at is the record. If there is a record of the mortgages being proposed on, we look at what the record shows, who the current owner is, and not all of this stuff going on behind the scenes. And that's why I said if you have, the original mortgagee was ameriquest funding.
No, the original...
Was ameriquest.
Mortgage
Mortgage Corporation. And that's what's the record. If you can show this court that there is an assignment from that original mortgagee to some other entity other than the plaintiff in this case that is recorded, then the court is going to take notice of that.
And if that is a assignment that was filed in this court on the other, for the other case, is that valid? The state filed it and swore to ameriquest?
Well, no, I thought you said it was a record.
And this is a record. I actually...
In the registry.
In the registry.
Okay, well then if you have that, then it may well be valid, and the plaintiff may well have a problem. If there was an assignment to them that was not recorded, there was an assignment to another entity that was recorded, I'll say in general, the court will follow the record in the registry.
Okay, and out of curiosity, because I'm just trying to understand this, because I don't do this for a living, is, and the big deal about them simply withdrawing the claim and refiling in a manner that doesn't have these issues is what? I'm trying to figure out why we're going through this process when it would be easy enough for them to simply withdraw and refile when they're ready in a proper fashion. Why are we wasting the court's time going through all of this rather than simply refiling? Because if you dismiss it, you're going to dismiss it without prejudice to do a proper understanding. No matter how much I bang the table for with prejudice, it's going to be without prejudice. So what is it we're spending our time here doing that my client is now spending more money in attorney's fees for me to go brief something when they could withdraw and come back when it's a proper time to file, as opposed to wasting your time without its full.
Okay, well, I mean, you know, you have a legitimate issue there, and Mr. Souza, when the court asks you, or asks your client to file explanations, when that notice went out, it's been, 2 or 3 months, I think. And I don't understand why these are still issues that haven't been resolved. When I set this up for a hearing, after you filed, indicating that your client had the assignment, I don't understand. And the issue was also raised on the qualification to do business in the state. I don't understand why these are still issues today. And Mr. Bond does have an issue there. I mean, a legitimate issue there. So, but anyway, I'm going to give you both 2 weeks to file a brief responding to this. But I am going to take Mr. Bond's comments into consideration, Mr. Souza.
Well, all I would say to that, Your Honor, is we received a text order that the plaintiff had shown sufficient cause, and the case was going to proceed to judgment. So I was not aware that there were any outstanding issues here today. I will confess, I've done a number of service members' cases. I've never been called in on a status conference. I wasn't really sure what we're going to do.
Well, the reason was because the court wasn't fully satisfied with what you filed, because, there were some issues there.
Okay, but perfectly fair, Your Honor. It's just that we received a text order from the court on January 20th that said we had shown cause and was going to proceed to judgment. So I didn't know these issues were still out there. I have been communicating with the Anson Street in-house counsel, and I want them to register and transact business in the Commonwealth. And I want to get an original new assignment in my hands so that we can record it. Hopefully that can happen.
Okay, but you do understand that if there happens to be another assignment from the first mortgagee of record to some other party, then you got a problem.
That may well be, Your Honor. I'm not aware of that. We've run title on this property. I would love to see that document. Maybe that assignment was subsequently released or assigned back.
Okay.
I don't know.
Well, I think maybe the 2 of you should communicate as well as working on your briefs to file.
I'd also like to ask, Your Honor, if I may, one, can we make it 3 weeks on a solo practitioner trying to handle some business? If we do 3 weeks, that would be fine.
Okay.
The other thing is that after the order came in, I then submitted another document that had a lot of information in it, which he then received. So he was aware that I was raising these issues subsequent to the order coming in, where I asked that the judge do something to undo the order, but at least take my brief into the record. I have a copy of it, and it was filed with the court.
Okay, but most of what was filed in your brief is not relevant to the service member's case issue.
And the second brief that came in, I believe, was in terms of a number of the issues I'm raising now.
Okay, well, the 2 issues that I think are very relevant are what the status of legal title is to that assignment, and the issue of qualification to business in the state.
And we're not going to do anything with regard to it's the wrong mortgage. That doesn't happen.
No, the court is going to look at the record and see what the assignment shows, and that's it.
Okay, I understand. And that would all have to be done with a separate suit in another court.
Yes, I'm not saying that you don't have legitimate issues to pursue, but that, in the service member's case, is not the venue to do that.
Fair enough. I appreciate that.
Okay.
That would be brief, Your Honor.
Yeah, so the briefs would be, 3/6, March 6th.
They tried to pass
Your Honor.
Yes.
On the table, I had asked for attorney's fees in the event that I'm successful. Will that still remain on the table?
Yeah, the court's not going to act on that today.
I didn't mean today. I meant that the other.
Well, depending on how this comes out,
you get that issue.
you can mark that up for hearing if you want.
Thank you very much.
But you should wait and see how it plays out. Okay.
Thank you, Your Honor.